Well, a new twist in a 16-year-old murder case. The suspect, Bobby McGee, has long been considered mentally incompetent, but he could soon go to trial. In 1998, McGee was accused of killing his wife, Helene. He was declared mentally incompetent in 2000 and sent to the Florida State Hospital. In 2001 and 2003, the hospital suggested that McGee had become competent, but both times the court disagreed. Well, now doctors say a new cocktail of medications could make McGee sane enough to go on trial. A hearing date is set for July 7th to determine if he is fit to understand and participate in the proceedings. And if he's found to be, a trial would begin just weeks later. So joining us now, former prosecutor Dan Schorr and trial attorney Heather Hansen. Thank you both for being here.
Great to be here.
Thanks. So Dan, there are two issues here. One, can he be made sane enough to stand trial? And two, was he sane enough at the time of the crime to be held responsible?
Right, and they're very different issues. There was a lot of bizarre behavior at the time of trial. For standing trial, the issue is whether he can understand the proceedings and assist in his own defense. And for over a decade, he's been deemed not to be competent. If he's ultimately deemed competent, then the issue at trial would be whether the defense can prove by clear and convincing evidence that he was insane at the time of the killing. But we're a long way from that, because right now he's not cooperating with these drugs that are supposedly going to make him competent for trial. And if he gets sent to a jail, which he will before trial, the jail can't even administer them against his will the way the psychiatric facility is now. So there's a lot of complications.
Yeah, Heather, about that, as Dan just said, as long as he's in this mental hospital, they can actually forcibly drug him. But the jail says they can't. But you say there are actually loopholes there?
Well, there's numerous constitutional considerations here, Patty Ann. I mean, if you think about it, he's got the right to privacy, the right to self-determination, procedural due process, the right to a fair trial. Can he interact with counsel if he is on these drugs? Do they put him in a zombie state? And in Florida, it's one of 10 states that the Constitution actually says you have a right to privacy under the Constitution. So there's a lot of legal arguments for his defense to make that he should not be forced to take these drugs.
And if he's not forced, he says, and his lawyer says, look, he's not going to take them, and then he's going to be a mess at the trial, and it's going to be a circus. Dan, what's the point? If he's already saying that, what's the point in going through with this?
Well, the prosecution's saying that he's intentionally not cooperating to avoid having to go to jail or down the road to prison, that he'd rather be in a psychiatric hospital, and that's understandable. It's probably a better place to be than to be incarcerated in a jail or in prison. But he did kill someone. He murdered someone, his wife, in a brutal way, and the state of Florida wants him to be held accountable. They're saying that he was competent at the time of the killing. He was not insane, and they want to try him for his crime.
The other thing about that, Patty Ann, is that it's so much more expensive for the state. It costs over $100,000 for the state to keep him in the hospital, and I think something like $17,000 to incarcerate him. So the state has a strong interest, and under the law, that has to be weighed against McGee's constitutional interests.
But, you know, Dan, critics, on the other hand, say that, you know, you can't make this about money, and that this hospital has repeatedly said, okay, every couple of years, he's sane now, he's sane now, and that they just want to get him out because it is so expensive, and that it's the motivation there is more financial.
Well, behind the scenes, motivation might be based on financial considerations, but you'll never see that as an argument in court. They'll never say in court, we need to try him because it's cheaper to keep him in jail. The arguments in court are based on whether he's competent to stand trial, and then if he is competent to stand trial, the issue at trial will be whether he was legally insane at the time of the killing. Of course, financial considerations might be in play behind the scenes, but you won't hear that actually stated by any official.
Right, but is that an accusation in this preliminary hearing where they're trying to determine whether he really is competent? Heather, is it going to come up that there might be financial motivations behind these hospital officials saying that they've analyzed him and decided that he's sane now?
Probably not. I think I agree with Dan that it's probably not going to come up. But what will come up is, doesn't he have the right to be tried in the same state in which he committed the crime? You know, he's not going to be found insane if he's competent and seems completely normal while he's trying the case. There are so many issues with regard to his rights, his constitutional rights to self-determination, that it would be really difficult for a court to overcome those based on simply justice, which we all argue is a great right, and the money.
So Dan, when it comes to whether or not he really was insane, you know, he had been married literally days when he started exhibiting bizarre behavior. He distributed this letter to the neighborhood, delivered it actually to some newspapers, saying that his wife was a disciple of the Antichrist and whatnot, and she filed for an order of protection against him, which was turned down. What do you think, based on your familiarity with the case, was he insane?
He was clearly emotionally disturbed. There's no doubt about that. But there's a big difference difference between being emotionally disturbed and having some diagnosed mental illness and actually being legally insane where you don't understand what you're doing or you don't know that it's wrong. Here he stabbed his wife brutally, and as you said, she tried to get an order of protection. A judge actually turned her down as she tried to get an order of protection, and it just shows how important it is for judges to take these cases seriously and issue orders of protection when a victim is looking for one. But as far as the trial, some states put the burden of proof on the prosecution. The defense here in Florida has to prove by clear and convincing evidence that he was legally insane at the time of the killing. That is a high hurdle for them to get over.
Yeah. They have a number of experts who have said he's schizophrenic, he has bipolar disorder. Ultimately, at this July 7th hearing, it will be a battle of the experts. The experts for the state will say that given these medications, he's completely fine and he should be given them. And the defense experts are going to say that it's impeding on his rights and that it does not affect the ultimate question of whether or not he's sane.
All right, Heather Hansen, Dan Schorr, thank you both so much for joining us.
Thank you.